That wasn't meant to prompt anyone, but thank you for doing that, Lacey. All right, well, thank you everyone for coming to our fourth A2J Tech event. My name is Victoria Pan. I use she, her pronouns, and I will be moderating today's panel. I know I speak for everyone at A2J when I say we really appreciate the continued support for these events. If you have any questions during this discussion, we have disabled the chat, but you are feel free to put in your questions in the Q&A at the bottom of the Zoom window, which does have an anonymous setting if you're feeling a little shy. We will reserve about 10 minutes towards the end of the event to answer your questions. So I'm going to turn it over to our panelists to do a brief introduction of their names, their preferred pronouns, and what they're currently working on. Jared, if you'd like to start us off.
Sure. I'm Jared Smith. I'm the Associate Director of WebAIM. My pronouns are he, him. WebAIM is the Web Accessibility in Mind project. We've been doing web accessibility work since 1999. And I just kind of help oversee a lot of our efforts here in consultation with clients, web accessibility testing, training. I also oversee the WAVE web accessibility testing tool.
Thanks so much for joining us today, Jared.
You bet.
Would you like to introduce yourself?
Sure. Hi, everyone. My name is Liz Valentin. I use she, her pronouns. I'm a clinical fellow at Suffolk Law School's Health Law Clinic. So I supervise law students in their last year of law school as they take on their first cases. Our clinic takes guardianship cases. We also handle medical debt cases. And we work with the clients who are appealing the denial of state and federal disability benefits. And I'm going to hand it over to Maggie, who is one of my former students.
Thanks, Liz. Glad to be here with you all. My name is Maggie Austen. I go by she, her pronouns as well. And I am currently seeking employment as a full-time attorney, recently barred in Massachusetts, and working on some side projects around election, ballot question, field ops, and some business administration work at the moment. But accessibility is really in my bones. So excited to be here.
Thank you so much for being here. And also congratulations on passing the bar, of course, as well. So I'm just going to jump into the questions. Just to get us all started, could you please each define what accessibility means to you? Maggie, I believe we're going to go in a reverse order, and you mentioned accessibility is in your bones. I'd like to hear your definition of it.
Great. So I think of accessibility as a platform for including the widest representation of human experience, diversity, and diversity. So accessibility is not only an idea or a philosophy or a posture, but actual tools or accommodations and modifications that designers and program administrators and lawyers and people creating laws use to create, I like to think of it as like create a level playing field. A lot of people use a fun image when they're talking about equality and equity. And the image is usually three characters looking at a baseball game or something on a playing field. And the image talks about equality as each character in that picture having one box to stand on to see over the fence. And talks about equity as depending on the character's height, they get more or less boxes so that everybody is able to see over the fence. And I like to think of accessibility as like part of that equity conversation, that ideally when we're talking about accessibility, we're actually doing barrier removal. So maybe we're taking down the fence that's impeding those characters' ability to see the baseball game. But if we can't take down the fence, then people need the right amount of boxes depending on their lived experience or their physical ability to be able to participate, to be able to watch that baseball game. And sometimes you even need to build a ramp up to the top of the boxes. So that's what I think of when I think of accessibility.
Thank you. And thank you for bringing up that baseball picture. I feel like people pass it around Twitter and Facebook, but you don't necessarily know what it means. So thank you for explaining that. Liz, anything to add about your definition of accessibility?
Well, I wholeheartedly agree with Maggie's definition. I think the only thing that I can add is maybe a perspective of what it means as arising out of federal law, which is under the ADA. If we think about what entities' obligations are under federal law, whether it is a place of public accommodation or a state or local government or an employer, different entities are required to engage in an interactive conversation with an individual with disabilities to ensure that their program is equally accessible to all individual users. I've summarized a big area of law with broad strokes. There's obviously a lot more detail and nuance built in, but the main takeaway I want to give to the audience members is that even under federal law, what's imagined is a conversation between two parties about what is and isn't reasonable and accessible. And I think that's something that a lot of people miss when they think about the ADA, the Americans with Disabilities Act, that it is expected that there's going to be a back and forth and a conversation. Before the ADA was in place, the expectation was individuals with disabilities would have to meet everyone else where they were at in order to participate in society and in community. And the idea of the ADA is to shift that burden to make it the halfway point, right? So that individuals with disabilities need to make it some of the way, but everyone else also needs to think about how to change their practices and their physical structures to be more accessible. What that means, however, is that everyone has to move out of their comfort zone and have a conversation where they meet in the middle. And there are a lot of good debates and discussions to be had about, well, what's the middle, right? How do you decide what's a halfway point between a user who doesn't feel like something is accessible and the provider of that service or that space? So in my mind, accessibility is about conversation and figuring out where that reasonable middle point is for all parties.
I love that. I love the idea of law as a conversation rather than something inflexible and not a living body. Jared, anything to add about your definition of accessibility?
Yeah, maybe just a little bit. Certainly it is equity, it's inclusion, and that end target of creating an environment for us at WebAIM, digital environments that are there. Our mission is to empower individuals and organizations to reach that ultimate goal of inclusion and equity. We also use the term accessibility, however, to define the process of getting there. Right. And Liz kind of talked about that a little bit, this middle ground. And sometimes I think that's helpful for us to consider that term accessibility could mean the end goal and the process of getting there. And sometimes that can cause a little confusion, maybe even a little tension when we maybe expect or demand perfect accessibility for an end user, while maybe not considering the processes and efforts and progress to get to that. So it's an interesting term, and I think those two ways it can be used are important to consider and differentiate.
Yeah, thank you for bringing that up. Jared, can you, along those lines, tell us a little bit about the work that you do at Utah State University's Institute for Disability Research, Policy, and Practice?
Sure. So our institute has been here for 50 years, actually a long time. We were involved very early in civil rights efforts for those with disabilities. WebAIM, our focus is digital accessibility, web accessibility, but we're housed inside this institute that provides a lot of other programs and activities centered all around disability and accessibility. It's a fascinating place to work, to interact with those with disabilities, those that are working on behalf of those with disabilities, to create a better, more accessible environment and world that we work in. We do a lot of policy work, a lot of research, development, consulting, and yeah, lots of things like that. So it's fun to be part of a much broader effort of accessibility, and then also to collaborate and interact with others like they're here today that have similar passions and interests.
Thank you. Speaking of collaboration, Maggie and Liz, you encountered an inaccessible court website while working together on the health law clinic that you mentioned in your introductions. Can you tell us a little bit about what happened and the advocacy that grew out of that?
Yeah, Maggie, I'll tee it up a bit and then pass it over to you. But so, as I mentioned, Maggie is a former student of mine, and last year, while we were working together in Suffolk Law School's Health Law Clinic, each student is assigned a number of different cases. And as I mentioned, all of our cases are in the umbrella of health law. So all of our clients, either themselves are individuals with disabilities or they have family members who are. Maggie did fabulous work as a student of the Health Law Clinic. She got a lot of great results for some of her clients. But one of the things that all of our students are expected to do is be the lead attorney on their cases and keep tabs on what's happening in all of their cases. And I think it was right around the end of fall semester as we were making plans for winter break and figuring out, how the students are going to plan to cover their cases while they're away from campus, which is obviously an obligation any attorney has, that Maggie came to me with a concern in one of her cases. So Maggie, I'll hand it over to you to sort of explain what happened.
Sure. So yeah, last year I was working on a guardianship case, which we had recently, prior to winter break, filed a complaint and pleadings with the Probate and Family Court in Massachusetts. And in order for student attorneys to file online, we work with our supervising attorney, which in this case was Liz, to do those online filings. And then in order to check on those filings, see if the court has ruled on them, if any of the forms or attachments have been approved, we have to go online through the public portal because we're not attorneys yet. We don't have an attorney login to the Massachusetts court's website. We use the public login. And I have a vision impairment. I use a screen magnification software. I use text-to-speech and sometimes text-to-speech software to use my computer, access websites, things like that. And I could not, for the life of me, get on to the Mass Court's public records page to check the status of my guardianship paperwork because they had a Turing test. So one of those challenge image CAPTCHA situations that I could not pass. And usually I have a lot of tricks and hacks to get around them. My favorite of which is asking other people to do them for me. But in this case, my software wasn't helping. And because of sort of the nature of the work, it always felt a little awkward to continue to ask for help. I came to Liz and said, hey, while I'm away, can you just check on the status of these things because I'm not able to log in on my own. And it got our juices flowing about how we could sort of leverage our role as the health law clinic and my status as a student attorney, supporting a client in achieving their goals under the law, to really do some advocacy around this issue. So Liz and I worked together throughout December, January to draft a letter to the trial courts, which I think they're going to share in the chat as for your reference, and a little bit about the broader story to help the trial courts see the issue with the Turing test with their challenge image and sort of prompt them to make it accessible. There's lots of accessible alternatives to visual only Turing tests, or to take it down entirely. So after what was actually a really short turnaround window, I think we sent it to them at the end of January, and we heard back at the beginning of February. The Mass courts decided to take down their challenge image in response to our letter, in response to our advocacy. Did I miss anything, Liz?
No, I think that's certainly all the substance of it. I just wanted to add that, part of our discussions as we were drafting that letter were to think, well, what are the trial court's obligations under state law and under federal law? And how do we word this letter? What's our leverage? What are, what can we point out? What are they required to do? If they're not required to do that, how do we argue that they should do it anyway, right? It became an exercise in thinking through, as an attorney, how should Maggie advocate for change? Which was great. As a teacher, I'm thinking, great, this lines up with my goal of training these student attorneys to become attorneys. But Maggie had a really powerful reflection on the other side of that. And Maggie, I remember you saying that you had submitted complaints like this in the past to other entities and organizations and not had as quick of a response time. But in this instance, you sent this letter and were immediately heard. And not to put you on the spot, but if you'd be willing to share a little bit about what your thinking was around that, because I do want to have a conversation about what it means to be an advocate, and can you be an advocate when you aren't an attorney?
I think I have a long history of advocacy prior to law school. I think being an attorney occasionally makes you a better advocate. And I think in this case, having the support of a bigger institution, having some technical skills around what kind of advocacy is going to create what kind of impact are powerful conversations. I really appreciated your teeing up about accessibility, Liz, in the context of it being a conversation. And, we all have different kinds of conversations throughout our lives in all kinds of ways. And I think as a person with a disability, conversations about requests for accessibility or requests for accommodations can start off as this inclusive, like, hey, I just want to let you know that this thing isn't working, start to the conversation, and can really quickly escalate to, a shouting match about, you have to be accessible and we don't have to be accessible, or we're trying to be accessible. And so I think kind of this project in particular, setting a different tone around how that conversation is had, and how you can put more of a let's work together on this and a more compelling argument behind you for why something should be accessible in a particular way, and how to make organizations or entities aware of sort of the bigger context of accessibility that a particular issue is in. I don't know.
Yeah, thank you, Meg. Yeah, I think often when attorneys talk about advocacy that they participate in, it might feel like there are these magic words and magic processes by which change can happen that are not accessible themselves, right? So I'm hoping that the conversation we have today, and I really encourage anyone in the audience to ask questions, is one that is accessible itself, right? Law is so frequently not an accessible conversation. And so we want to make sure that the tools we're giving you and the information we're giving everyone feel like things that you can use to make sure that the institutions that you work with and work for and use are accessible in ways that work for you.
Yeah, thank you so much for teeing that up with my next question, because I do want our audience, with the disclaimer that, of course, please look up the local regulations in your state. I do want them to come away with some tools for if they do encounter any of these situations where you have to remind people you do have to be accessible, you do have to make these conversations. So what are some of the current federal and state laws and regulations that do touch on accessibility? And I will punt this back over to you, Liz.
Yeah, so as Victoria said, right, every state is going to have different laws about accessibility and discriminatory practices, and what are and aren't discriminatory practices. Under federal law, at least, the key law to know about is the ADA, the Americans with Disabilities Act. But that is not the only law that touches on disability. There are a lot of issue-specific federal laws, everything from touching on voting to touching on airlines. So it may be that you're operating in an area that has, in addition to the ADA, additional obligations that arise. So certainly if you're thinking about working on something that engages with or involves these laws, definitely get legal counsel, and please don't use what I'm saying now as the entirety of the legal advice that you're relying on. But in general, I did want to speak a little bit about the ADA. So the ADA is made up of 5 titles, or 5 chapters. And the first one touches on the obligations that arise in an employee-employer context. And that only applies to employers that have 15 or more employees. So that's Title 1, is accessibility in the context of the work environment. Title 2 is about obligations that arise for state and local government. So government entities, right? What obligations do government entities have to be accessible? And when I say state and local government, right, that includes a lot of things. That includes courthouses, that includes town meetings, that could include government agencies like the Department of Children and Families or the Department of Public Health. So that's Title 2. Title 3 is a tricky one. This is where we talk about places of public accommodation. A place of public accommodation is a privately held entity that opens itself up to the public. So what are examples of that? Well, restaurants, movie theaters, doctors' offices, law firms, right? Places that are private businesses and entities, but they are open to the public. They are covered by Title 3. Title 4 touches on telecommunications, and as we will talk about a bit today, is a little bit outdated because the ADA was passed in 1990, and that was a very different communications landscape than the one we live in today. In Title 5, everyone's favorite title is miscellaneous, and that's just where they shoved all the other extra bits of the law into. So just to recap, the ones to really be thinking about: employer, employee, state and local government, and then places of public accommodation. Now, I am by no means an expert in the case law around places of public accommodation, but I will say very briefly that it's a currently very contested area of the law, whether a website, which is owned and operated by a private business, is a place of public accommodation, right? Does that obligation to conform to the ADA, make sure your services are equally available and accessible to all your users, extend only to your storefront? Or does it extend as well to your publicly facing website? Federal courts have come out in different directions on this. And as far as I know, the Supreme Court has not taken any action to resolve this open-ended question. So there is a lot of litigation in this area right now, and a lot of unresolved questions of law. I think I will leave it there. That is a very short overview, but probably as much as I'm qualified to speak on. But of course, maybe towards the end, if people have more specific questions, I'll see if I can provide some helpful answers.
Thank you so much. Jared, with your work with WebAIM, I'm sure you've run into the type of controversy Liz has been describing to us. What are some of the current laws and regulations that you tend to rely on when you get some pushback for things like that?
Sure. Well, most of it is around the Americans with Disabilities Act. That really is the central law where we're seeing most action, lawsuits, complaints, and so forth. There is Section 508 of the Rehabilitation Act. It defines technical accessibility requirements for the federal government. And it's important to note that the ADA does not have those technical standards yet defined at all for digital accessibility. Its civil rights law says you can't discriminate based on disability, but it does not define what that is yet for the web. There are technical requirements for, say, a wheelchair ramp. It can only be so steep, right? And it's easy to measure and determine whether that ramp is in conformance with those technical requirements or not. But we don't have that yet for the web. So it's kind of an interesting nebulous place. There was a process about 10 years ago to define those technical standards for the web. And initially it got a lot of resistance from private entities, saying things like, oh, if you define these technical standards, we're going to get sued. And now all those businesses are saying, we're getting sued left and right. We need technical standards defined in the law so we know what the requirements are. I equate the current environment sometimes to getting pulled over on a street and given a speeding ticket on a street that has no speed limit signs, right? How do we, was I going too fast? What is too fast? What are those technical requirements? Of course, we know that most websites have pretty significant barriers to those with disabilities, right? If you're doing 90 in a school zone, it's hard to argue that you weren't going too fast. And that is the case, I think, for many of the websites that are out there. There's clearly demonstrable barriers that are out there. Pretty easy to argue that there could be discrimination in those cases, but it is a little more nuanced just because we don't have those technical standards. Section 508, because it does codify technical standards in federal law, is often one that's referred to. The technical guidelines in that law are the Web Content Accessibility Guidelines. Now, the Web Content Accessibility Guidelines, WCAG, I may say WCAG. If I say WCAG, that's what I'm referring to as those technical guidelines. Those are formulated by industry. It's a standards open body that has defined those technical guidelines that have since been adopted into many legal environments, including Section 508. Most of the complaints, the lawsuits that we're seeing around the ADA reference those guidelines. It's kind of a de facto standard for the ADA right now, even though it's not defined in the law. So understanding and implementing and testing to those guidelines is certainly what we would recommend to help mitigate potential risk and potential claims of discrimination, just because it's a pretty good, it's not a perfect measure, but it's a pretty good measure of accessibility and thus potentially discrimination.
Thank you. And I do want to note that my coworker Bailey is very helpfully dropping a lot of links in the chat. So for our attendees who want to jot down these notes or take note of these regulations, we will be sending out an email with these links. So you don't have to worry about hurriedly copy and pasting them right now. Maggie, last but definitely not least, any other laws, regulations that we should keep in mind for accessibility purposes?
Yeah, I think two things to note as you sort of caveated, Victoria, looking up the regulations in your jurisdiction, online world, your jurisdiction isn't just the brick and mortar where the brick and mortar location is. Nowadays, online shops don't even have a physical building, or they have a manufacturer component and then this really wide reach. So it feels like a tricky area of the law. But if your organization is incorporated in a particular state, looking to that state, here in Massachusetts, for example, we have a state regulation, state laws that largely mirror the ADA, but actually include a broader section of what they call protected classes. So groups of people who are protected against discrimination in Massachusetts is a wider representational group than just federal law, for example, and can have a little bit of a broader reach. In other states, that'll be different. So really thinking about looking at in your local area. And secondly, I'll say a big piece of the advocacy that Liz and I, the letter that we worked on and the advocacy of working with the mass trial courts is that the Massachusetts court system itself had made a commitment to accessibility. Lots of companies, lots of entities out there have things out on their websites or press releases or documented commitments to diversity, equity, and inclusion. Maybe they have documented commitments to accessibility in a particular way. I can send around the one from Massachusetts where they have their own internal guide to web accessibility that was created and promulgated by their Executive Office of Technology Services and Security, and being able to point to those sort of internal commitments and those internal guides to say, hey, you said that you're going to follow WCAG 2.1 AA standards. I'll also probably use WCAG, but that is the WCAG Web Content Accessibility Guidelines. You committed to being a place where people, regardless of their ability, are welcome. And in order to live up to those commitments that you made, these are the recommendations we have. These are the kind of standards you should be aiming for.
Thank you so much. I am trying to keep an eye on the time, but I do want to make sure that our attendees have additional tools other than law again, no legal advice is being said here in this webinar, to make their web content more accessible. Jared, I'll start off with you if you want to do a quick plug for WebAIM as well.
Sure. Yeah, there are many resources out there that are really helpful. Bailey linked to the Web Content Accessibility Guidelines themselves, and that organization, the World Wide Web Consortium, has lots of documentation and resources around those guidelines themselves to help you understand them. It's pretty academic. It's a technical standards body, and it's important, I think, to acknowledge that the web is very technical. Therefore, web accessibility is going to be fairly technical and can be a little bit to wrap your head around because of those technical standards. And there sometimes is subjectivity to understanding those guidelines. Wheelchair ramp, so steep, so wide, pretty easy to measure those kinds of things, right? It's very straightforward, but determining equivalence of a very rich online experience is a little more nuanced. So there are some good resources there. With Section 508, there are also some good resources and documentation within the federal government. And then there is webaim.org, our website. What we try to do is take a lot of that really technical and academic, really complex stuff and boil it down so it's much easier to understand. So we have just a rich wealth of articles and resources on our side that can be helpful. We also have the WAVE accessibility testing tool, which is the most commonly used accessibility testing tool that is freely available. If you want to get a sense for how accessible a website might be, using that testing tool is a great place to start. It's important to keep in mind it can't tell you all aspects of accessibility. If it doesn't find errors, it doesn't mean that it's compliant or accessible or non-discriminatory, but it's a great place to get started to get at least defined readily detectable accessibility barriers.
Thank you. Maggie, I'm curious to know if you recommended any tools in that letter. You mentioned a little bit about struggling with CAPTCHAs, things like that. What are some other tools that you might know of for increasing web content accessibility?
Yeah, get rid of your CAPTCHAs is my biggest piece of advice, or just make them really accessible. There's lots of research out there about which challenge image plugins that you can use on your website, by making a database or an information inaccessible to a robot, thinking about what level of human usability is necessary to access it. Like, you have these two objectives, keeping the robots out, I guess, and letting the humans in, and just really taking that step back to think about what the broadest range of human experience is that's going to be showing up to your website. And so I think my biggest piece of advice is involving a really wide range of individuals in your user testing, involving people with disabilities in your design, is just going to help you sort of from the onset have a more inclusive website, have a more inclusive design. There are organizations that do some of that usability work. I used to work for them. One of them, the Institute for Human-Centered Design, IHCD, to add to the acronym soup today. They do great work with user expert led programs where they involve people with disabilities at any stage of the design process. There's also NCAM, the National Center for Accessible Media. They have a lot of great resources, and these organizations are listed at the end of my letter, and I can get to you in the chat. I also think one of my cautionary tales is a lot of websites use little like accessibility widgets. You'll see them sometimes at the top or the bottom or the side of a website, and it's the little accessibility icon that you might be familiar with from like your phone apps. And you expand that and it like lets you change the contrast. It lets you make the font size bigger or smaller. Sometimes it even has a plug and play, turn on text to speech feature. Those sort of plugins, I don't know if that's the technical term for them, are not a, oh, we did it, now we're accessible, okay, great option. They're a bonus. They're helpful for people who are accessing your website from like a computer that isn't their usual device where they have their software. They're great for people who are maybe new to coping with a different kind of disability, but they don't solve all of a website's accessibility challenges. And so I always like to include a cautionary tale about those sort of accessibility plugins that you see a lot on websites today.
Thank you. That's a really interesting spin on some of the tools that we're discussing. Liz, I'm going to popcorn over to you. Are there any tools that you particularly recommend, especially to your students or in an educational setting, about making content more accessible?
So I don't have any more tools to add to what Jared and Maggie touched on. Certainly when I have conversations with my students about legal writing, we talk all the time about thinking about who the audience is. And I think that that's applicable advice to anybody who's putting content out into the world, right? Just as Maggie said, who is the audience you're targeting and how do you create content that is accessible to them? That is not only a question of disability, that is a question of language access, that is a question of readability, right? What I would just add to what Maggie said in having inclusive design is reaching out to individual users and soliciting their input is a fabulous way to get ahead of a lot of problems. But ultimately, it's really impossible, especially in the space of technology where things are moving so quickly and evolving so rapidly, to get ahead of all kinds of concerns. And so I would just say, when a user comes to you and says, hey, your finished product still isn't doing it, still has some bugs, has some problems, or I have recommended fixes, right? Receiving that with an open mind and engaging in that interactive conversation means that you're going to ultimately have a product that's even stronger, a website that's even more accessible. And so engaging your users in the design process is not just a static part of creating a website, but an ongoing and never-ending iterative process. And so given that, it helps to engage in it with some good faith and good humor, since it's so much a part of the work.
Thank you. And speaking about feedback and conversation, without getting into bashing anyone, I would like to discuss some common accessibility mistakes you may have seen from other organizations or clients, things like that, maybe just using your internet in your everyday life. Maggie, you mentioned CAPTCHAs. I'm going to popcorn back to you. Other than the CAPTCHAs, what are some pretty common mistakes that you run into?
Common mistakes. I think one of a sort of controversial topic in user design world is fonts and the use of fonts in digital spaces, especially. Not all fonts are created equally, and I can nerd out over serifs and sans serif font all day long. But I think one of my talking to people over the years around fonts is around contrast and fonts. And so thinking about when you're changing from one font style in a website to another style, going from heading to body text, you might keep the same color because everybody's about their branded colors. But I'm sorry, if your branded color, when it's in one font over another font, no longer passes muster from a contrast perspective, then it just means that your page is way less readable for way less folks. I also think one of the traps too is the sort of posture or perspective of, well, this is the way we've always done it. I'll never forget a user testing experience where one of my users, a man with a vision impairment, said, why would they change from Times New Roman? Times New Roman is what they've been using for years. This was one of my users who was there, and I was hoping he was going to say, I can or cannot read this font. And he sort of swallowed the party line about this is the way it's always done. This is the branded text, right? At the end of the day, asking him the question though of oh, but how readable is that text for you? Is it the most accessible option? And showing him the same paragraph in a couple different font types really got us to the side of being curious and being more inclusive, rather than continuing to be stuck in the "but this is our brand" or "this is how we've always done it" conversation. So I think trying to avoid those conversations, the "this is how we've always done it" conversations, or but this is our brand package conversation are really important in the context of this work when thinking about how to make something usable to the widest audience possible. Having to get outside of those what we always do or what we need to do kind of attitudes is really important.
Yeah, that's a great point. Thank you for bringing that up. Liz, I'm going to popcorn back over to you. What are some common accessibility mistakes that you might have seen or might anticipate?
I think that when things are moving quickly is when accessibility is often sort of deprioritized. And so in thinking about what times in your organization or in your services do you see that things have to move quickly, well, then plan ahead when things aren't moving quickly to think about accessibility. So at the very minimum, I'm thinking, in the court setting, providing a piece of information to all users. Hey, you're about to get a lot of documents that aren't accessible. Here's what you need to do to make sure that they are accessible. So what I would say the mistake is not planning ahead for times when things are going to be moving quickly and getting hectic.
Thank you. That's a really interesting answer that I wasn't anticipating, and I'm really glad that you brought that up. Jared, any other common mistakes that you can think of?
Sure. That's something we're asking all the time. We want to help make the web more accessible. We need to know what the common and most impactful issues are. So at WebAIM, we have done a lot of research in this area. One thing we do is regular surveys of users with disabilities to ask them, about their preferences and the things that are impacting them. And so those survey results are available on our website. Maggie indicated CAPTCHAs for several years. That was the top, most impactful thing that many users with disabilities just despised and were most negatively impacted by. Contrast is another one that's commonly cited. We also do an annual analysis at WebAIM of the home pages for the top 1 million websites. We call it the WebAIM Million. We have a report that we publish every year, and it's available online, where we use automated testing to test 1 million homepages and collect that data to get a sense of what the most common accessibility issues are that are out there. So you can look at that report just real quickly. The most common things that we see are low contrast text, by far the most prevalent accessibility and compliance failure that's out there. Images that are missing alternative text, that's text that would be defined for images that would be read by, say, a screen reader in place of that image for someone that can't see that image. Empty links and buttons, those are functional elements that visually might convey something but don't have any text that define what those things are for. So a screen reader user might hear link or buttons, something that's not particularly helpful. Missing form input labels. So that's essentially defining text for like text boxes and check boxes that defines what those things are for, so that that's apparent to those users. And then missing document language, telling the technology that an end user is using what language that page is in so that it is read appropriately. Those are the most common things that we're seeing in our analysis of those top 1 million websites.
Thank you so much. I think, Maggie, you have one more thing that you wanted to add?
Yeah, I was just thinking about mistakes, and I like to think about accessibility oftentimes from like an attitudinal perspective. And one of the examples that I remember from years and years ago, probably in an early ADA training I was a part of, was the example of it's a snow day and your building has stairs and a ramp to get into the building, but the snow removal team comes and everybody's waiting outside to get into the building. The stairs and the ramp are all covered with snow. If the snow removal team removes the snow off of the stairs, then only the people who are able to climb the stairs can now get into the building. And anybody who needed the ramp has to wait until the ramp is cleared off from snow. But when you take a more inclusive accessibility perspective, if the snow was first removed from the ramp, then everybody could get into the building. And so I think that attitudinal perspective, even in the digital space, I don't know, maybe Jared has a digital example of shoveling out a ramp instead of a staircase, but I think that attitudinal perspective of, oh, like accessibility, we'll do the ramp second. We'll put the accessibility features in later, is a mistake, because really, if you zoom out, if you take a minute, to Liz's point about slowing down, you'll realize like, oh, actually being inclusive from the beginning just allows that many more people to access this product or website, or in my snow case example, the building.
One thing I might add there quickly is that with the power of the web and the technology that we have, we don't have to approach it as stairs versus a ramp, right? We can just build one like ground level entrance that's accessible to everyone in the same way. That's the flexibility of the web, and that approach of kind of creating a separate experience. We don't have to do that. We can include that accessibility natively and beautifully into our existing experiences without fundamentally changing what they do or what they present. We can just make them accessible. Most of it happens under the hood of our website.
Oh, Maggie, you're muted, I think. Did you have something that you wanted to add to that?
Oh, I was just saying thanks. I
Yes. I am seeing we have a boatload of questions, and I want to make sure that we get to all of them. Thank you again to Bailey for putting them in a format I can easily access. So my first question is, and this is a free-for-all, you can all jump in and answer. With more interactive web-based resources, are there guidelines or tools to check the accessibility of these types of programs, for example, guided interviews or something like that?
Yeah, I can maybe answer a little bit, with those types of experiences, because they are very experiential, like automated tools are not going to be highly helpful, right? They may identify some technical aspects of accessibility, but maybe not that broader experience. So I'd probably just say, user testing has already been indicated, including users in that process to give feedback and actually testing it with those users, including users with disabilities, to help identify what those potential barriers might be is probably the best thing I would recommend.
Any other thoughts on this question, Maggie or Liz? If you'd like to refresh on what that question was, it is in the Q&A at the bottom of the window.
I don't know a lot about those particular interactive online spaces, but just to build off of Jared's point about user testing is remembering that your user's time is valuable. And so anytime you're even asking participants on some kind of interactive platform to then provide feedback at the end, there's not many of us out there who are really altruistic and will just do something for the sake of doing it. So what's the incentive? What's the compensation for my time, taking my time and my professional lived experience as a person with a disability to give you feedback about how your online platform is or isn't working for me. So thinking about ways that you're compensating those users for their time and their talent is really important.
Yeah, thank you for bringing that up. All right, the next question is, sorry, this is a great question. It's just making me laugh because it feels a little bit like I'm in law school and I have to answer this. If you are making an active effort to try and make your website accessible, but it doesn't completely meet the WCAG standards, which we touched on as not being codified into law yet, is there still a chance that you can be sued for not meeting those standards?
I'm not seeing that question show up. Sorry, would you mind rereading that one?
Yeah, sure. If you are making an active effort to make your website accessible, but it doesn't completely meet the WCAG standards, is there still a chance that you can still be sued? This is turning into a little bit of a hotline question, so I understand.
Yeah, I mean, the answer is it depends.
Yeah, that's what I figured the lawyer answer would be.
Yeah.
I think it's possible. I'm not really aware of any such lawsuits that are kind of focused on really like nitpicky aspects of technical accessibility that really are centered around true aspects of equity and discrimination, things that just really don't work at all. Those guideline failures generally represent end user barriers, not always. So there's I think that potential, but if you are putting in a reasonable effort, if you're engaging with your customers, with your users, there's mechanisms there to ensure that if there are barriers, that they are addressed in a reasonable time and manner. I think the likelihood of a lawsuit for some thing that's not really truly an end user barrier would be pretty unlikely.
Right. Again,
hold off on weighing in on the likelihood or unlikelihood of a lawsuit, but if you are a business that is for profit and you have a budget, then some part of that budget should be going to legal compliance if this is a area of possible risk for you. But the first step is to engage with all of the fabulous tools that Jared and Maggie have touched on. That would already be a great first step, because there are plenty of websites that aren't engaging with that content. So I would start there and not start from a perspective of what's the worst case scenario, but maybe just figure out where can I start, right? What is the information that's out there that might help inform a good faith effort in designing an accessible website.
Absolutely. And I think that goes to the perspective shift that Maggie was mentioning with the stairs and the ramp example. Well, the next question, people are very fixated on legal action. Do you believe that legal action is the only way people will take web accessibility seriously in the years to come? And I guess the existence of the previous question might be an indicator of an answer to that.
I'll go ahead and jump in. I actually think the PR nightmare of being inaccessible and not inclusive is, the court of public opinion, as they say, is a much more powerful tool. The loss of revenue for a company for not being accessible to a consumer population of people with disabilities is, I think, a bigger incentive for being inclusive, other than just the plain old fact it's the right thing to do. And so I was at a networking event recently where a family law attorney said to me, I tell my clients, you can either pay me and give me the money so that you can try to keep some of your money, or you can give the money to whatever this other party is. And I think about that in the context of this kind of litigation. Companies that are being faced with issues around website accessibility, they can either give their attorneys money to argue it for them, or they can give user testers and organizations like WebAIM and Jared, a little bit of a boost and bring their websites up to speed. I think either way, it's going to cost something. It's just a matter of what bucket that cost falls in your line item.
There's no doubt that lawsuits are a strong motivator in this area, but they are not the most positive motivator. Very often what they result in can be some maybe animosity against the audience that actually is trying to be served by that. They're just asking for their civil rights to be provided, right? And some basic levels of equity, but sometimes the lawsuit can result in that. It can also result in entities just meeting the minimal requirements. What can I do so I won't get sued? And that often isn't a good measure of true equity.
Yeah, I wholeheartedly agree. And one of the things that can get people to care about this issue is diversity, equity, and inclusion, right? If you have a diverse workplace where all of these perspectives are already built into your organization, then it's not going to take an outside user or entity to bring to your attention that this is an important issue, and then you'll care already. So I would just say that laws and lawsuits are when everything has gone wrong. But there are plenty of ways to, shoot for the ceiling instead of the floor, and try from the get-go to get things to go right.
Yeah, if we know about 20% of the population has a disability, if you're an organization and wondering about your website accessibility, and it's like we don't have anybody, we don't have customers we're aware of, we don't have employees with disabilities. To me, that would suggest maybe a culture that is not really embracing that diversity, equity, and inclusion. Because if we were really representative of the population, we would have those among us, and have those resources available to help us ensure better accessibility. So sometimes those systemic cultural aspects of just accessibility and inclusion, starting there, building a better culture within your organization, then the website and all of those other results tend to come a little more natural from that.
Yeah, and to loop back to, I think, what we started this conversation out with, right? We can think of accessibility as an endpoint, but we can also think about accessibility as the process of getting there. And so a lawsuit and an outcome of a legal case, okay, maybe that's an endpoint, but isn't it way more fun to think about the process of getting to accessibility and the conversations that come out of it?
Absolutely. I'm realizing we only have 4 minutes left, and I want to give you all, I know, Jared, you're going to have to leave pretty soon. So I want to give you all an opportunity to go over again your contact information, where people can find you if they have more questions, more things that they want to clarify on based on this conversation, and maybe a key takeaway that you're hoping the audience can take away from this conversation. Jared, I'll start off with you. So you're free.
Yeah, webaim.org. You can go there and contact. My email is jared@webaim.org, jared@webaim.org. And and our website has a lot of resources that may be helpful. I think if I'd maybe leave kind of one thing, and I think this has kind of been a little bit of a theme that we keep coming back to, is there's a lot of focus on the technical aspects and the legal requirements and all of that. But fundamentally, it's just kind of about giving a damn, right? Just caring a little bit and having some overall concern for the quality of your website, and then ensuring that it's going to be available to a broad array of users.
Thank you so much. Liz, last thoughts, where people can find you?
Yeah, my email is fvalentin@suffolk.edu. I'm guessing Bailey will add that in the chat. And please, you're welcome to reach out to me. This is not my legal area of expertise, however, so if you reach out to me with a legal compliance question, I'm probably not going to be of much use. And I just want to echo what Jared said. That's a fabulous takeaway, right? Getting involved in this area, being curious, learning about what accessible websites looks like, that's a fabulous first step and a good place to start.
Thank you so much. And Maggie, where can we find you, and where any last takeaways, any last thoughts?
Sure. So I'm Maggie.Austen@gmail, and that's MAGGIE.AUSTEN. Austin like Jane, not like Texas. That's what I like to say. And yeah, I think great takeaways. I think, this is these sort of compliance attitudes, again, like that being the floor of this conversation, not the ceiling, like Liz said, I think is really important. And I think people with disabilities are all around us. And so involving them in your work, involving them in your design projects is really important. And I think it'll surprise you who around you does identify as being a person with a disability or doesn't. Them identifying as a person with a disability doesn't mean that these regulations and these designs and your website isn't for them. So including people with a wide range of lived experience and ability in your design processes, I think is my big takeaway for you all today.
Thank you so much. Thank you so much, all of you, for joining us today. I apologize if we did not get to your question, but we will be touching on this idea of accessibility in design and diversity, equity, inclusion in multiple of these events. So please save your questions then and come to our next event if you would like to hear it discussed. But other than that, I thank you for being a great audience. I thank you all for being great speakers, and enjoy the rest of your days. Bye.
Thanks all. Bye.